And thank you, everybody who's joining us today. I really appreciate you being here and giving me this opportunity to share some great financial information. I'm Catherine Chris Martin. I'm with EY, about 16 years of experience, and I really enjoy sharing financial information and helping people um, really get control of their overall financial fitness. Um, I uh, I just came back from a trip. I was able to go with my girlfriend. We went out of town to go to a concert. And on the way back, I ended up sitting with a nice man who's in the service. And we had a whole lesson on Social Security as we flew together from one city to another. And I left him with a couple of resources that he could use. So, I mean, honestly, I love sharing this information. And today's topic is really understanding estate planning. You know, you haven't really finished your retirement planning and your financial planning if you haven't figured out here's what happens when something happens to me and where do things go. And that's what estate planning is all about. We want you to understand what is a part of your estate. And we'll look at kind of the pros and cons of the probate process and learn how what trusts can do in their role in estate planning. Because a lot of the guidance around estate planning starts with the state you live in. Some states you can just do a will and that's fine. Other states, if you just do a will, it could take months and months before your estate will be settled. So we look at the different documents and then also know which important estate documents are needed. And then we'll talk about some estate tax issues. And of course, always share with you the resources and things that can help you in your planning process. Of course, through Wespath, you have a variety of benefits you can get information on by looking at wespath.org. You can also go to benefitsaccess.org. You'll need to sign in there. That allows you to be able to even change your investments and look at information about your investments right there on wespath.org. And you can always call if you have questions. So I just encourage you to use the resources that you do have. And then through the EY program, I've been really privileged to work with the EY team now a little over 10 years, and there's so much that we can help you with. There's not just the information on our website, which is great. There's calculators, articles. We even have monthly webinars you can attend, but you can call and make an appointment with one of our planners. And even if you just don't even know what to do, you can call a planner and say, here's my situation. I don't know what to do. You can call as often as you wish. It's completely confidential. It's unbiased. And it's really included as a part of the Wespath program. So there's no additional charge for any of the resources you see here in front of you. And we have an app for that. Also, our planner lines open long hours from 9 a.m. to 8 p.m. Monday through Friday. That's Eastern time, Monday through Friday. We are closed certain holidays. And you can make an appointment and talk to the same planner each time. And one of the most important things is our planners are trained on your benefits. So they understand like the parsonage allowance, they understand the different situations that might be more unique to your work situation. So I just encourage you to give them a call. You can also download our app. We've got a cute little graph there on the chart. One of the things you can do on our website is you can link your financial resources, your bank account, checking account, your credit cards, and so on. You can link them to our website and we can help categorize your expenses. So if you're trying to work on any of those topics we talked about in the Social Security in your retirement or in dissolving that debt, these tools can really help you with that. And our team can help you understand a lot of these different concepts. As you go through, I always encourage people to make a plan and put together your own personal action plan. So just a reminder of how valuable that can be. So create your own personal action plan throughout this presentation and any other presentations that you go to. I have my own personal action that I have to do by October 31st of this month is my deadline, and it does involve estate planning. I have to update my letter of instructions. I have additional information to put in that. So I'm going to be working on that to meet my deadline of October 31st. So keep that in mind. So how much do you know about estate planning? Well, let's just walk through some statements about estate planning, and I'll tell you if they're true or false. So these are some of the things we commonly hear from people. Estate planning is only important if you're wealthy. True or false? Yeah, that one's false. Estate planning is only for people who are old. That's also false. You don't know when something could happen. I mean, we certainly saw that when the pandemic hit. You had people of all ages who were impacted by that and who passed away unexpectedly. And in some cases, of course, had no plans in place. Joint ownership of property makes estate planning unimportant. That's not true. And spouses automatically inherit everything. That's also not true. And a lot of it depends on the state you live in. I was looking at a poll recently. I'm always reading articles about retirement planning, estate planning, financial planning, getting out of debt, and so on, because I teach the topics, always looking for other information I can share with people. One of the statistics in a poll from caring.com caught my attention because according to that poll, 67% of their respondents said they don't have a will. They don't have anything. Now, if you fail to plan, the state you live in actually has a plan for you. It's called dying intestate. It means you don't have a will. Every state already has a plan for what happens to your property if you die without a will. So it's sort of up to the state you live in to decide. The state you live in would even decide what happens to your children if you have children under 18. So what can estate planning do for you? It can help distribute your property according to your wishes. It can help you take care of your survivors' needs. It can specify wishes for medical treatment, manage gifting, and so on during your lifetime or even when you die, and help to minimize estate taxes. Now, for most of us, most of the people I'm talking to, estate taxes are not a huge deal. The current limit to give away your estate without estate taxes, it's over $12 million. Now, it is going to change at the end of 2025, but the new limit will be probably close to 6 million. So again, I'm usually not talking to folks who are in that particular tax bracket, but it's just good information to understand and know how that system does work. But what is an estate? Your estate consists of everything you own, as well as any money or assets in your name. So do you have a home? Do you have a retirement plan? Do you have a life insurance policy? Do you have a bank account? If you say yes to any of the above, then you have an estate. And then what an estate plan can do goes back to what I was looking at there. It can help distribute property according to your wishes and help take care of your survivor's needs. Well, how does it do that? It starts with a will. What a will does is it makes your wishes legal. It helps your heirs handle your estate during a difficult time. I mean, we're upset, if somebody we love has passed away, that's very stressful already. And so here's this document where you have your chance to say, here's what I want to happen, so that whoever's taking care of this will know what to do. And so what you can do with a will is you can document who will receive your property when you die. You can name guardians for your children if something were to happen to you and your spouse or partner. And most importantly, you can appoint an executor. That's the person who is responsible for handling your estate if something were to happen to you. If you don't have a will, the state you live in is going to decide what happens to your property. The state you live in will appoint an executor. At the probate court, they basically have a list of attorneys who are up next to handle estates, and they're just going to appoint one of those people. Your estate will be paying that person for their services. So the nice part about being able to do your own planning is you get to decide who's responsible for that process and hopefully name somebody that you know and you trust that would be able to handle that circumstance. And then a lot of people think that your will controls everything. It actually doesn't. Your will really controls property that's not already spoken for some other way. A lot of financial assets are actually controlled through contracts. So look all the way over to the left side of the screen. That's my contract box. What's in there are trusts. If you were to do a living trust or an irrevocable trust, that's where that would fall. It's a contract. Retirement plans fall into that box. There would be 403Bs, 401Ks, IRAs, and life insurance. Those all go to the named beneficiary, even if my will says something differently. Like my will might say everything goes to my two sons if something happens to me and my spouse. But my financial accounts might say everything goes to my best friend because I'm thinking my best friend, she'll step in and she'll manage the money for them, right? You know who gets the money? Even though I wanted it to go to my two sons, it goes to your named beneficiary. And rules are different by state. I can't tell you how often money goes to an ex-spouse because people didn't change their beneficiary designation. So that's something you have to keep in mind is make sure you update your beneficiary designations. Now, another way property might pass is through a joint name. So if you have property where your tenants in common or your joint tenancy with right of survivorship, that will determine how those properties go. If your tenants in common or community property, then it goes through your will. If you're joint tenant with right of survivorship, it automatically goes to the joint tenant. And then everything else is over on that right-hand side. Your will actually has to go through probate, which is a specialized court system, and they then approve everything being handled and how it's handled before it goes to your heirs. So by will basically means that it has to pass through the probate process. This can really be a challenge because in some states, you might have property, which is very valuable. I have a family member that has a situation. They live in California. Her most expensive asset is her home. And I had been on her to do something about her planning. Well, in California, if you don't have a trust and if you don't have anything else set up, your house is going to have to go through probate. And there's a statutory or regulated fees. So based on the value of her home, her estate would probably have to pay about $15,000 for the house to go through probate. Meanwhile, she wants it to go to her two daughters. So what they've done now, and this is in California, is they've set up a living trust. The house has been retitled. It's now owned by the trust. When she dies, that house is now automatically going to be owned by her two daughters without having to go through probate, without having to pay those statutory fees of $15,000 or more. So the key to doing good estate planning is to talk through those types of situations and set them up correctly. I will tell you that in Texas, you can give away your property without it going through probate. You have to do what's called a transfer on death deed. And actually, California has another thing similar to that, where even without setting up a trust, you could do this other document where your property could pass without going through probate. But the key is to make sure that you've done it correctly before something happens to you. So you want to make sure that you take action to reduce any potential probate costs. For your action step here, it would be review your beneficiary designations, including your 403B, your pension plan, life insurance, if you have IRAs, if you have a 401k, make sure you review all of your beneficiary designations. The other thing that you should do is on bank accounts, they don't usually have a beneficiary. What they do instead is called a transfer on death statement. So on my bank accounts for my husband and I, we jointly own those financial assets, but it says transfer on death and it goes to our two sons. So if once both of us have passed away, they automatically will split that money between the two remaining people for transfer on death. That's the way to do it if you're talking about a bank account. So for the probate process, they're going to process your will by the special court, which is designated to probate wills. They approve your executor. They name a representative if you don't have a will. And then the judge supervises and approves the distribution of assets and payments of any debt. Definitely there are pros and cons of the probate process. If you don't have everything go through a trust, then things will have to go through probate. So the pros, of course, the court is going to determine that the will is valid, not valued, and they allow the will to be challenged. They are going to supervise distribution, and the executor has to report to the court and the heirs how the distribution was handled. So you have a little bit of legal oversight on that. The negative, one of the biggest negatives is the cost. Another big negative is it can really take a long time, and those records are all public records. They're not private. If you did a trust, that's a private contract and that's a private record. As an example, so I have a family member who had a trust. We were able to basically distribute their estate within 2 months. It would have been shorter, but they owned a home and we actually had to sell the home and it sold pretty quickly. So the estate was handled within 2 months. I have another family member who died intestate. They didn't have a will at all. Everything was submitted to the probate court for approval. It took 9 months before it got to the top of the stack of estates that were waiting for approval. So we had to wait over 9 months before the estate could actually be settled. So the probate process and it was all these statutory fees. If you're talking about your property going through there, that can be pretty expensive. So it is important to understand that and then figure out what can you do if you're trying to avoid the probate process. What can you do? One would be by owning assets jointly, because those are going to supersede what the will states. Create a living trust. That's what my aunt did in California. Name beneficiaries for things like your IRA, your 403b, your pension plans. Name a payable on death person for your bank accounts, or certainly give away things while you're still alive. If you're thinking about who you want to be your guardian, um, if you're naming guardians for children, that's another thing you can do within your estate planning. You can name a guardian for your children. You can actually name two different people. One would be the day-to-day guardian where your kids would be living. The other would be your financial guardian. These can be the same person or it can be different people if you want to have some oversight. Here's one very important point I want to share with you. If it's different people, choose people who get along. They need to all be working on behalf of the children. So you don't want people who just can't stand each other. And one person saying, I need this money, and the other person saying, well, why are you paying this and not that? So you don't want those types of conflicts while the kids are being taken care of. But do make sure that you name somebody that's trustworthy and most importantly, that's going to be accepting the responsibility and be willing to raise the children how you want them to be raised. You know, as people of faith, if you want them to be raised within your church environment, you want to make sure you find somebody who's going to do that. As far as the financial side, that might not be the same person. And that's why, again, you want to have people that'll get along because they also need to be financially astute, ethical, and trustworthy. And it might be the same people or it might be different people. Just make sure they get along. As far as your executor, it's somebody who's going to carry out the wishes stated in your will. It does take time and effort to be an executor. I've done this on behalf of family members. And it definitely takes some time. So you've got to pick somebody who has that aptitude, that ability, that can handle really the stress and the work that'll be involved in doing all of this in order to distribute assets as stated in your will. After your will is prepared, you want to pick where you're going to put that and make sure it's safe. A lot of people will say, well, I'm just going to put it in my safe deposit box. But what happens is, even so, my husband and I, we actually have a safe deposit box, but if something happens and he passes away, if they know he's died, that safe deposit box is on lockdown until the court demands that it be opened, until the court, not demands, until the court states it can be opened. And so I wouldn't be able to access that box. So what you could do is you each have a safe deposit box and you put the document in each other's safe deposit boxes, or you just figure out where you want to put it. That's a safe place. And make sure your family members know where to find it. They need to know where to find these documents when the time comes. And you can make copies as well if you want to make copies. And then you should actually review this every 3 to 5 years, or if you have a situation where there's a marriage or divorce, birth or death, a relocation, if you change states, only if you change states. These laws are state specific, and also if there's a change in the laws. So definitely you want to do that. My husband and I actually redid all of these documents for ourselves about 3 years ago, and we did that because we also have a living will. I'll talk about that one in another slide. We have a document called that living will, and that living will in Texas, they changed the format and it needs a lot more information. So since we were going to do that anyway, I just decided, let's just go back and re-look at everything and go ahead and have the documents redone. And we did, because even though we still lived in Texas, we had relocated. And so we had them done by a local attorney. And that way, if there are any issues, there's somewhere for the family to go to right here where we live, rather than trying to track down that attorney that had done them long ago when we lived in a different part of Texas. And so we went ahead and redid them, and mostly we redid them though because of that living will, knowing that our current one was not as comprehensive as what they now require. So if there are changes in the laws, you want to make sure you're using the most recent version of those documents. And then a trust basically moves things away from your specific individual ownership. So here's how a trust works. So this is my aunt. My aunt owned the property. My aunt is the trustee. She gave the property to the trust. The trust is the legal document that the trustee is responsible for putting in place. And she is the beneficiary. And then she's also named successor trustees. My cousins are successor trustees. My cousins are successor beneficiaries. And so it basically takes care of everything. But the next big step, first of all, this is a much more expensive document to prepare, while a will might cost around $300 to $500 to do your will and those other documents. That trust document for my aunt was a little bit more involved because of some specific issues that they had in the family. And that cost about $3,000 or $4,000 to prepare. So a trust can be a lot more expensive, but a trust also allows you to put strings on the money where a will doesn't. With a will, as long as they're 18, they get the money outright. With same with if they're a beneficiary, they get the money outright if they're a beneficiary, as long as they're 18. But if they are, if you want there to be terms and conditions, like I want to make sure that the money's only being used for school or whatnot, then you can put that in the trust. But the other next step when you create a trust is you have to retitle any real property. So the home that my aunt owns in California had to be retitled so that it's now owned by her family trust. And that's how they're able to get it out of the probate process, because otherwise it would have to go through probate. There are also irrevocable compared to revocable trusts. Most living trusts are revocable. It means you can change your mind if you want to. Your mind can't be changed once you passed away. And so when you die, it then becomes irrevocable. Whatever it says must go according to that. But during her lifetime, if my aunt wanted to make changes to that trust, she could make changes in her lifetime. Once she dies, it becomes irrevocable. But if you have a lot of money and you're looking to get money out of your estate, then you could look at creating irrevocable trusts. I'm always reading articles about some of these people. My favorite, I loved Prince, or also the artist formerly known as Prince for a period of time out of Minnesota. I was a big fan of his work. It took 6 years after he died to settle his estate. He had no legal documents, and it was over $156 million that was distributed. By the time his money was distributed, 3 of his half siblings had actually passed away. Many of them had actually sold their rights to his money to another independent organization, and so their share went to the people who had bought them out. But it's just a reminder. He paid also, his estate paid estate taxes on a whole lot of money that had he done some irrevocable trusts before he passed away, they wouldn't have had to give as much money to the federal government and to the state of Minnesota. So a lot of us don't really have those types of problems, but it's just a reminder of the importance of doing this so that your family is well taken care of. So estate planning, in addition to the first 2 things which we've just talked through, they can also specify wishes for medical treatment and handling your personal affairs while you're still alive. One of the things we suggest you do, and this is one of the documents my husband and I prepared, is to do a durable power of attorney. It grants another person the ability to act on non-health related matters if you become incapacitated, and it really reduces the psychological, financial, and physical burden on your family. A girlfriend of mine, her mom wouldn't do a durable power of attorney. She didn't have anybody named. Her mom is now 91, and she's really not able to handle her affairs. So instead, my girlfriend had to go to court. She's had to pay attorneys, and she's been appointed her mom's guardian so that she can handle her financial situation. But if you appoint somebody with your durable power of attorney, then you don't have to go through that guardianship. A lot of times people think of this as just something that you would do for you and your spouse, but if you're a caregiver for elderly parents or grandparents, you also need to look at these types of documents. My grandfather actually lived with my husband and I the last 5 years of his life. Before he came to live with us, we updated his durable power of attorney. And I say we as in my grandfather and I, we went to the attorney, and my grandfather directed him to get these things updated so that my husband and I had that ability to help him through those last 5 years of his life. The other document you want to look at, or the other documents, are a living will and a healthcare power of attorney. The healthcare power of attorney, that allows somebody to make healthcare decisions on your behalf. And then the living will allows you to identify specific services if you aren't able to guide your own care. So you're always able to guide your own care if you are physically and mentally capable of doing so. But if you became incapacitated, but you're still here, this gives a person you trust the ability to say, this is what I want or don't want at the end of my life. This is what I want or don't want as it relates to healthcare. So that can be very important. So we do suggest you do all three of these documents: your power of attorney, it does need to be durable, your living will, and your healthcare power of attorney. Those might be on one document, but they're considered three different documents. And then your letter of instructions, that's what I need to update. Your letter of instructions, this is a non-legal document and it can be changed at any time, but it basically tells my family a whole bunch of information. It says, here's why I'm doing what I'm doing. Here's where my advisors are, my financial advisors. Here's who you need to call and contact should something happen to me. Here's what you're going to need as far as these different documents. Here's how I want to be buried or cremated or whatever it is that you want. And that's what that letter of instructions does. It really helps them understand what your intent was. The will is legal, or the trust is legal, and those have to say things in a lovely legal, a lovely legal way that's not always easy to understand. This is your chance to say, here's what I mean. So my document for my letter of instructions, it says, when we pass away, we actually have, my husband has kids from a first marriage. It says that the belongings in the house, they belong to these kids. And for the kids of my husband's who live far away, I've left it up to the executors to decide, do they want to invite them to come here or not? I mean, they may be here anyway, and you can allow them to take things if you want to. But if you're saying, I don't even want to go through that, then you can decide what happens to the things in this household. The executors will have the right to do that, because I want it to be as streamlined as possible. So that's the kind of stuff I can say in my letter of instructions. I also remind them that these days, what a lot of people will do, because most of our kids don't want all that stuff we've collected all these years and all the stuff I kept of my grandmother's and my mom's and so on, a lot of people have estate sales. Well, my kids probably don't know about that because they're not that age. I tell them, hey, you guys take what you want and then have an estate sale, because that money can go to you, because otherwise they'd probably give all that stuff away, when instead more money could go to them for future things that they might want to do. So all of that's in my letter of instructions. It also says, here's where these documents are, here's these insurance policies, here's where these certificates are, here's the contact information. And so you want to do something that will help them navigate and take care of all the stuff that has to happen. I remember when my grandfather died, he actually had some life insurance from his former employer, which is pretty unusual these days. I was working with an attorney, but it was only like $1,500. And so the attorney basically did nothing. Like, he's supposed to be helping me, but he never sent anything to my grandfather's former employer, because I think he kind of felt like $1,500, who cares? And I'm thinking, I care. So I was able to contact, because I was involved in my grandfather's estate, I contacted the company and we got that $1,500 to then be distributed to his heirs. Otherwise, the attorney wasn't going to do it, because he felt like it really wasn't worth his time, because I guess he'd have to charge for his time, which would have been more than $1,500. So this can tell you, here's where all this stuff is. And then don't forget about digital things these days. You know, without planning, your survivors may not be able to access your computer, your phone, your digital media, your social media, any of these other things. Figure out what to do and how you want to handle these things. And I've got down here some steps to take. A letter of instructions, include access and information, and make sure your heirs know where to find this stuff. We've got all this stuff in one place together. I regularly remind them. I like, they come visit. I'm like, it's over here. I want you to do this and this and this. And they're all like, no, 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 we don't want to talk about it. And I'm like, well, now's the time to talk about it, because there'll be a time where I might not be able to talk about it. So I want to make sure I share that information. So Keep in mind all these different things. So we've got estate planning documents. Here's what you need during your lifetime. Financial power of attorney, that durable power of attorney. It needs to be durable because that allows it to go in place if that person becomes mentally or physically incapacitated. That's what's important about that. I used to read a column out of the Houston Chronicle, and it talked about people writing in to the attorney saying, okay, my spouse has dementia or Alzheimer's, and I really need to sell the house to continue to pay for our care. The first question was always, do you have a durable power of attorney? Because if you do, you're fine. You can sell that asset even though it's in your spouse's name. But without the durable power of attorney, you're back where my girlfriend Shelva was, and you're going to have that guardianship done, which means you got to go to court and get legal paperwork. And by the way, I just said her name. If you know her, don't tell her I told you. Okay, I'll just tell her and then we'll be okay. I just realized, oh my gosh, I said her name and it's a pretty unusual one. But make sure you have that durable power of attorney. Also, power of attorney for healthcare, that living will, that one that says, here's what I want to happen or not happen if something happens to me and I can't make my own decisions. Trusts can help, and also making sure you retitle your assets. If your house is now owned by the trust, you have to retitle it. The documents that go into place when you pass away will be your will, your trust, your beneficiary designations, keeping in mind your beneficiary designations are actually going to be the leader. It's going to go to whoever you've named as a beneficiary, regardless of what you said in your will. So if those are different, they're different. And that's where the money will go. Your letter of instructions and document locator. For me, that's one document. I have it all in my letter of instructions. It's like 3-4 pages long, going through all this information. And our suggestion here is really to meet with an estate lawyer to update or draft important documents. Now, a lot of people will say, well, can't I do it on my own? You can. As a matter of fact, let's see, I know this because of Aretha Franklin's estate, but there are, how many states now? There are currently 26 states that allow you to do what's called a holographic will. If you just write it all out by yourself, you can do that. As a matter of fact, what we learned from Aretha Franklin's situation is she had about 3 different wills. And in the end, they found one will that was like tucked in the couch that was discovered after one of the first wills was probated that was in her handwriting. It had been done more recently, and the court ruled that that was the one that was valid. So even though it was written in hand by hand, where the original ones had been done by an attorney, and they found it in the couch and not in some safe place, it just didn't matter. The court ruled that document was valid, and that's what they went by, and it had totally different designations than the other 2 wills had done. So you can do it on your own. You can certainly use some of these online services, but I always like to tell people the problem with estate planning is if you've done it wrong, we're not going to know until you've died, and then it's too late to fix it. So it might be worth it to go ahead and work with an estate lawyer. And in our case, because my husband had children from our first marriage, I thought it was important because I wanted to make sure that when he passes away, something should go to all of the children. But I also wanted to make sure that the children we had together were taken care of. And so we started our estate planning many years ago when they were a lot younger, but things have changed over time. So figure out what you want to do and then take that action step. Don't be that 67% that has absolutely nothing in place for a plan. Also, as far as managing gifting to loved ones and charities during your lifetime or when you pass away, you can actually give away a certain amount of money every single year to as many people as you want to with no gift taxes, and it doesn't count towards your estate exemption. Oh, that's funny. I forgot. I said 12 million, but it's actually up to $13,610,000. So you can give away $13,610,000. That's your lifetime exemption for gift taxes and estate taxes without any additional estate taxes. Again, on this law, though, the law that changed it, where it's currently this high, that is going to sunset December 31st of 2025. But it's going to go back to a little over 5 million, and then that's going to be adjusted for a 10-year period based on inflation. So my guess is it's going to be well over 6 million, even when it goes back to the lower number. The gift tax doesn't apply, though, if you directly pay for another person's medical or educational expenses. It also doesn't apply if you're giving gifts to your spouse, as long as your spouse is a U.S. citizen, or giving gifts to charity. Now, if you're trying to reduce taxes, state taxes through gifts, you can reduce your income taxes um, if you're gifting that income producing property. That will reduce the size of your estate at when you die. Also, gifts to charities can reduce your income taxes during your lifetime and also reduce the size of your estate when you pass away. The main thing we always remind people of is before you make a gift to your children or a charity, make sure that you and your spouse will not need the assets. Because if you do an irrevocable gift like that, unless they can somehow prove that there was fraud or something else involved, that money is gone now. It belongs to those people or that other organization. And that's what's most important about that. Now, what can estate planning do for you finally? It's just help minimize estate taxes. They look at all that you own to determine your overall gross estate. So it's your retirement account assets, life insurance, any assets you own outright, half of what you own jointly or as a community property, and any revocable trust assets. So for my grandfather, he had a living trust. My aunt has a living trust, but those amounts, the value of her home, it won't be taxed in the probate process, but it will be included as a part of her gross estate. Then we subtract out any liabilities and expenses. That's your adjusted gross estate. At that point, you can give away things. If you have a spouse who's a US citizen, you can give those to that person. There's no estate taxes on that. You can give away to a 501c3 charity if you've got charitable organizations. And then what's left is your taxable estate. And then they calculate that by looking at that. So here we've got an example. We've got Josh and Amy. They've got money in their 403bs, money in their IRAs. And the other things they own jointly, they have some mutual funds and the value of their homes. So you can see the total of their whole estate is $2 million. And overall, their gross estates would be $1 million each. So that's how they kind of figure that out when you have joint assets like that. Now, of course, in this case, we're well below the 13 million, well below the 6 million. So they probably don't have to worry about estate taxes or any of that type of planning. And that number is going to be pretty high. You can see in 2024, it's 13,610,000. I always feel like I'm talking about monopoly money. When I talk about big numbers like that, it's like almost inconceivable to me. Some people do have that issue though. And then next year, what they'll do is they will adjust it for inflation. So it'll be up from that. Given what they've done with Social Security had a 2.5% increase, I would think they'll probably still be below 14 million for 2025. But then in 2026, it's 5 million, but they're going to go all the way back to 2018 and adjust it for inflation all the way up to 2026. And that's why I think it's going to be over 6 million at that point. The top estate tax rate, though, once you get over that number, you're going to give 40 cents of every dollar to the IRS. And then depending on the state you live in, there may also be state taxes. So some additional ways to reduce your taxes would be direct payments for tuition or medical bills, charitable deductions, marital deductions. As long as your spouse is a US citizen, you can give an unlimited amount to them. There's a unified credit, and these last two are very important, I think. If you are married, you actually have the ability to give away double whatever the limit is. When the first person passes away, you should file an estate tax return, even if that person doesn't owe taxes, and you're going to basically check a box which will allow you to use the total amount for both of you when the second person passes away. So if you do have quite a bit of money, that's something you want to make sure that you have the ability to pass up to double whatever that number is for married couples. So if it's 6 million, you could be looking at the ability to still pass $12 million between the two of you, even if one person had passed away previously. The most important thing I think you can do here is really have that conversation. What happens if I die? What happens if you die? What happens if we die together? Really important if you have children from a first relationship to make sure that they're not cut out from everything, because how you give your property away could determine that. For my husband, what he could have done is he said in his documents when he passes away that everything goes to me and then it's passed according to my will. But what if I don't name the older children in my will? Then they wouldn't get anything. So we talked about all that stuff and we made sure we set it up so that something would go to each one of the kids. If you're looking for a lawyer, you want to find a lawyer who specializes in estate planning. They should act as a legal counselor and educator, and then consider the fees based upon your needs. Can they communicate on your level? And there are definitely ways to search for an estate lawyer. Now, what I will tell you is our team can help you understand which documents you might need, but we're not a law firm and we can't prepare any of these documents for you. Ultimately, you would need to find a lawyer. And again, you can look at online resources. Online resources might be great if you don't have a more complex situation, like there's no kids from a first marriage. It's just the two of you, you've been together these years and whatnot, and you all agree on what's going to happen. You might want to do that. But most importantly, it's do something to make sure that the documents are in place if something should happen to you or to your spouse or to both of you. And then when should you review your estate plan? Well, certainly if you get married or if you get divorced, you should review it if there's a birth or a death in the family to the spouse, the beneficiary, executor, and so on. If you relocate to a different state, you need to have it looked at. Not if you relocate within your state, but a different state, if the laws change, and then periodically every 3 to 5 years. I knew it was time to review our stuff because my husband and I were talking and he told somebody, well, here's what's going to happen when 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 we die. He said, here's what's going to happen when we die. And I'm over there like, no, that's not what the documents say at all, because I'm not a lawyer, but I talk about this stuff all the time and I know exactly what was going to happen. And that's when we went back to go back and have that deep conversation, because initially when we did things years ago, my husband and I had everything went to each other and then it would eventually get passed down. And now that all the kids are older and we have a better idea of what finances we need for the rest of each of our lives, we went ahead and we totally revamped it a few years ago. So now we have it done completely different, but we're all on the same page as to how it will happen. And that's what's most important. And then don't forget, you do have some resources with EY. You've got our planner line. You can talk to them. We're not attorneys, but we can certainly help you understand what might be best for you depending on the state you live in and depending on your family situation. And I talked about family situation, and at the same time, I may have people on here and you are single or a widow or divorced and don't have children. They can help in any situation. I always think of, I have a very good friend and she is a widow, totally different circumstances, doesn't have children of her own. That money that she's saved up will eventually go to her siblings, and then some of it will go to her nieces and her nephews. It doesn't matter your personal situation. Our team can assist wherever you are in your life. So just know that you can call them. You can use the resources on our website, on the EY Navigate website. You can actually attend classes that we have through our EY team as well. Those are not Wespath specific. Those are going to be of a generic nature because we do have other clients that have our services. So those are really going to be very generic in topic. But if you call the planner line, they know your benefits and they can help you with your planning process. So here are all the things they can do for you. They can help you perform an analysis. They can help you prepare to meet with an estate lawyer. You call our number, 9 a.m. to 8 p.m. Monday through Friday. And then most importantly, just think about what 3 actions will you do as a result of coming to our class today or of watching the replay. And I'm going to check in with Frank and see if you have any questions.
There are no questions or anything in the chat box.
All right. Well, thank you so much for your time and your attention. If you'd like to give us feedback on our course today, all you need to do is text to this phone number, Workshop Wespath. It's WWKSP. I used to be able to say that, Workshop Wespath. And they will send you a link to the evaluation, and the class number is 43942. So thank you so much. I hope you wrote some things down in your notes and you're going to get working on your personal action plan.